Hi everybody, Dana Sparks, broker of Maximum One Greater Atlanta Realtors. And today's contract tip has to do with the exhibit, the GAR exhibit, the right to request repairs. Property sold with right to request repairs. And that is GAR exhibit 273. We are having all kinds of issues with this exhibit in this market, and I want to just do a brief video on some of the issues to be aware of. So, I don't even know where to start. This exhibit, if a buyer and a seller go under contract with the buyer's right to request repairs, that is in place of a due diligence period. A contract would not be binding with a due diligence period and with this exhibit right to request repairs. The intent is that, well, let me explain the difference. The difference is a buyer purchasing a property or going under contract with a seller with a due diligence period. The seller grants the buyer the right to terminate the contract for any or no reason. They don't even have to say what the reason is. They don't have to give the seller the opportunity to address any concerns. The buyer may simply terminate and the earnest money will be protected. So the buyer has however many days in the time frame buyer and seller negotiate for due diligence period. So it is a free look for a buyer. And again, it is wide-ranged, open-ended. A buyer may terminate for any or no reason. And again, they don't have to tell the seller what it is. A property that is sold with the right to request repairs, the only way a buyer may terminate is if the buyer and the seller do not agree on addressing the repairs as that is defined and outlined in that exhibit. So the intent is to give a seller that, on one hand, that would be a bit more preferable for a seller to accept this exhibit because the buyer, once a buyer and a seller go binding, the buyer doesn't get a free look. It limits their termination with respect to this, specifically on repairs. But now we have to look at that exhibit and see what the repairs are that are specified under which a buyer may terminate. It's not any and all repairs or replacements. It is specified to, there's a certain procedure that the buyer must do. The buyer must hire an inspector, and the repairs that get negotiated to be addressed must be defects. So here's where we are having the problems. The problem is on the inspector. The inspector, let me look at the exhibit again. The inspector is defined on the exhibit, and it states, and again, this is GAR Exhibit 273, and it says the term inspector shall mean a person or company with specific professional expertise in property inspections or in an item, building product, or condition contained therein for which the inspector is inspecting, examining, testing, and or surveying. With respect to inspections for termites and other wood-destroying organisms, the term inspector shall mean a licensed pest control operator. So here in Georgia, it is a bit open-ended. There are some, where's my mouse? There we go. Sorry about that. There are some certifications that inspectors may get, but they're not required to get, such as there's an ASHI certification, CABO certification, so forth and so on. So there is, again, that is a bit open-ended as to what an inspector is. What constitutes an inspector that has the professional ability to determine what a defect is. The next issue has to do with defect as defined in this exhibit. And again, the exhibit defines defects. And that it specifically states in paragraph 5B, the term defect shall mean any infestation by termites, insects, or other wood-destroying organisms, or any condition, building, product, or item of the property, or portion thereof identified by an inspector in a written report which, number one, is in a condition which represents a significant health risk, including lead-based paint and lead-based paint hazards, or an imminent risk of injury or damage to persons or property. Number two, a defect is something that constitutes a violation of current laws, government codes, or regulations, except if it had been grandfathered in because it was initially installed or constructed prior to or in accordance with the applicable laws, codes, or regulations at the time it was installed. Number three, it is not at the present time in good working order and repair, including damage caused by termites, infiltrating pests, and or other wood-destroying organisms, excepting other normal wear and tear. And then it goes on to talk about certain building products which are considered defective products in and of themselves by some class action lawsuits. For example, some siding products and piping and things like that that have popped, and shingles that have popped up in the past. So here's the problem. We are having buyers and sellers going under contract with the buyer's right to, with the property, with the right to request repairs, and they're sending over an amendment that lists everything on the inspector's report, including cosmetic items or things that don't fit this definition. And so, number one, well, and then the other question is regarding the definition of defects, what is a defect? For example, if you have a house that has windows with double pane glass and the seal has been broken, and so the window is all cloudy, is that considered a defect or not? Is it defective because the seal is broken and it's cloudy? Or is it not defective because the window is not broken and it is still keeping the inside air inside and the outside air outside, and it's more of a cosmetic issue? Very, very vague. And we are also having, again, buyers sending over an amendment requesting the seller to repair or replace items that clearly are not defined as defects. Landscaping items, missing shingles. A missing shingle does not make a roof defective, so forth and so on. So a couple of things, and in that exhibit, it goes on to say there are time frames. There's many time frames in there. There is a time frame to negotiate through these items. And bottom line is, if the buyer and the seller don't come to an agreement on the items that the defective items that the seller is going to repair or replace, the exhibit states that the contract terminates. It doesn't specify what happens to the earnest money. Now, so those are the three main issues. What is an inspector? Does a buyer's inspector meet the terms of the definition of an inspector? What are defects? Does what the buyer is asking for meet the definition of defects in that exhibit? If not, and the seller asks for these items to be addressed by the seller, is the buyer in default of the contract or not? And what happens to the earnest money should the contract actually terminate? So those are the three big issues that we have in dealing with a contract that goes binding between a buyer and a seller with the buyer's right to request repairs. So a couple of things to bring to your attention. In Seth Weisman's The Red Book by Seth Weisman and Ned Blumenthal, he does address this issue. This issue is addressed, and part of this issue is addressed, not all. It does address the inspector, and that it is, in essence, fairly vague. And it does have, there is a special stipulation, or basically an admonition, that buyers and sellers would need to add in a special stipulation that the inspector be ASHI or GAHI member, so forth and so on, for some sort of certification. And the other thing is again with the defects. And it says, an item is considered a defect if it meets any of the definitions as I addressed in that actual exhibit in and of itself. One admitted weakness of the definition is that it is very general and leaves room for the parties to debate whether an item or condition in the property is actually a defect. Unfortunately, with the housing stock in Georgia varying in age from brand new to over 300 years, it is difficult in a few short sentences to come up with a one-size-fits-all definition of a defect. And again, some of the examples would, so what do we do? So further on in the Red Book, it states that the above examples, and one of those examples would be the broken seal in a window. The above examples illustrate there may be no clear definition of the term defect. While there is not yet case law interpreting the definition of the term defect, courts will likely apply a reasonableness standard when it comes to whether a particular condition is or is not a defect. The courts will also likely place heavy reliance on the conclusions of a professional home inspector who, in theory at least, should be able to give more of an objective opinion on whether a particular item of property is a defect. Again, the example is, let me give you the examples outlined in the Red Book. What happens when a buyer and a seller disagree on whether an item is a defect? Suppose, for example, that the buyer requests the seller to, among other things, replace as a defect an old-fashioned electrical circuit box with screw-in fuses because the inspector believes it's a fire hazard. The seller agrees to fix all the other items on the buyer's amendment, but asserts the circuit box is not old or defective in any way, and it was grandfathered in at the time that house was built. Another example is a buyer who requests the five windows in a 10-year-old house be replaced because the inspection reveals that the seals in the windows are broken, causing them to fog. The buyer maintains that since the inspector noted the seals are broken, they fall within the definition of a defect under the contract. The seller asserts that the windows are not defective in that the glass is not broken, they open and close properly. The seller takes the position that the fog in the window is merely cosmetic and that the alleged broken seals are merely normal wear and tear. So who knows how a judge would decide? So the question is, in the above examples, buyer and seller can argue and even litigate over whether these items constitute defects or not. And further on, if the contract terminates, if the buyer terminates, did the buyer default by a wrongful? Did they terminate wrongfully because they asked for items for the seller to fix that weren't defects, or were they not defects? Another issue that we've had is buyer and seller go under contract with this right to request repairs exhibit, and then the buyer and the seller attempt to negotiate financially with an amendment to change the sale price. That's all good and wonderful, and parenthetically, buyers and sellers dealing with repair items financially is a better resolution than arguing over what is to be repaired, how it's to be repaired, who is to repair it, when it is to be repaired. Either you handle it financially with a decrease in sale price, or addressing it with the sale price, closing costs, or at closing from the seller's proceeds, the seller paying a certain vendor X amount of dollars. But nevertheless, with respect to this discussion, buyer sent over and the amendment to, let me tell you what that amendment is called. That amendment is Amendment F273, Amendment to remove the inspection contingency. And it specifically states that, number one, the right to request repairs contingency set forth in the property sold with right to request repairs exhibit is hereby deleted. And number two, the seller agrees to repair or replace in a good workmanlike manner the following defects, so forth and so on. So in this particular situation, buyer sent over that amendment. The seller sent over an amendment to change the sale price. Well, if a buyer and a seller are going to handle it financially, and they never came to any agreement on the sale price to address in lieu of negotiating through these defects. If the buyer and the seller are binding with the exhibit right to request repairs, and they end up handling it financially with an amendment changing the sale price, you must include that very first sentence that says the right to request repairs contingency set forth in the property sold with right to request repairs exhibit is hereby deleted. So just because, let's say they had agreed on sale price. Well, just because they agreed on sale price, what happens to this exhibit? You must, whenever, this is generally speaking, whenever a buyer and a seller go binding with an exhibit, and then they handle it an amendment to address that exhibit. I'm making things confusing, but you need to state whether you are complying with the terms of that exhibit or whether the amendment is in place of what the parties had agreed to when they went binding with this exhibit. So in other words, if there is the property sold with right to request repairs exhibit, parties go binding, and then it's handled financially with an amendment. In that amendment to change the sale price, you must state that the exhibit is no longer a part of the contract and is hereby removed. And then lastly, what happens to the earnest money? Well, I have addressed this in other videos where in my writing special stipulations video, and unfortunately, GAR does not address the earnest money in this exhibit. We have brought that up to the GAR Forms Committee and hope that they will address that for the 2022 version of the contracts. What happens to the earnest money should the contract automatically terminate if the buyer and the seller don't agree on the defects to be repaired or replaced? Nevertheless, you need to, since that is missing from this exhibit and missing from a lot of your special stipulations, you need to add in a special stipulation regarding what happens with the earnest money. But I just want to let you know from a broker perspective, the intent is that if the buyer and the seller do not agree on these defects to be repaired or replaced, the buyer is not obligated to go through with the purchase. It is a contingency. And the reason I say that is because the amendment to remove this exhibit specifically states that it is a contingency, the right to request repairs contingency as set forth in the property sold with right to request repairs exhibit. So it is a contingency, meaning the seller understands that the whole contract is contingent upon the buyer and the seller working through these items. So as a broker, my interpretation is that if a buyer and a seller cannot agree on these items to be addressed and the contract terminates, the buyer will get their earnest money back. The buyer is not to be penalized if a seller and a buyer don't agree on the items, on the defects to be fixed. Now, it gets back to, well, what if the buyer asks for things that are not defects? And there has been a lot of argument back and forth among agents and among buyers and sellers regarding the earnest money, and the earnest money being a penalty against the buyer for asking for things that are not defects. Well, we've gone into some discussion about that term being extremely vague and would be left up to a judge in a case-by-case situation to define what a defect is, and an inspector. And then you have to define, well, the competency level of the inspector. So, nevertheless, Earnest money. So number one, you have to determine if the contract automatically terminates, is there a default? If there's a default, who defaulted? Did the buyer default by not agreeing, or did the seller default by not agreeing? Did the buyer default by asking things that were outside the scope of what they agreed to ask for? And the penalty in the GAR purchase and sale agreement, the penalty for default, there's not a penalty for default. The remedy for default is the earnest money as liquidated damages. Liquidated damages and penalty are two completely separate legal issues with respect to a contract. And the liquidated damages, if a party defaults under the GAR contracts, the liquidated damages is what the parties agree to as a reasonable assessment of compensation for that contractual default. And specifically, it is not designed to be a penalty. A penalty in a contract would be an amount, a dollar amount. You would in essence estimate the dollar amount of the actual loss of one party or the other, whatever loss was incurred, plus additional money as a penalty for creating that loss for the other party. Liquidated damages is, again, an assessment, a predetermined, a pre-estimate of the amount of loss suffered by one of the parties. So the earnest money is not designed in the GAR contract anywhere to be a penalty for anyone's default. So number one, is there a default? And number two, is there a penalty for that default, or is it liquidated damages? So where do we stand? Bottom line. Bottom line is, again, the intent and the intent of the exhibit, again, is a buyer contingency. Just like any buyer contingency, if they can't come to terms, they get their earnest money back, they go on their merry way and go find another house. The seller still has the house to sell to another buyer. They still have, all they've really lost out on is time. So where do we stand? Again, this exhibit is, on one hand, intended to be more preferable to a seller because a buyer can't just walk away for any or no reason. On the other hand, you get into a lot of legal definitions and questions, and I think in this market that we're in right now, we are in a very fast, busy seller's market right now. And it's very, the answers would end up being settled on a case-by-case situation by, well, first line is if a buyer and a seller don't agree on the disbursement of the earnest money in the termination, then the holder of the earnest money, they're going to make their interpretation of the contract and what happened, number one. Or the holder of the earnest money can interplead it into a court and let a judge decide. And a judge is going to decide one way or another based on any particular situation. There's not going to be any sort of blanket judgment. Again, it depends on all these factors we have addressed. So bottom line, what should you do? Well, you need to have these discussions with your buyers and your sellers. You need to find out information about the inspector, and it depends. A due diligence period might be more preferable for all parties because of these issues. So again, this has turned into more of a complicated exhibit than it first seemed upon first addressing it. I have addressed this exhibit several times in previous videos, but I'd love to hear your comments below on the good, the bad, and the ugly with your buyers and your sellers using the going under contract with the right to request repairs exhibits. But I hope this contract tip helped you out. Couple things is you might want to define what an inspector is, or require that inspector have certain certifications. You absolutely want to address what happens to the earnest money should the contract terminate. And you might want to predefine what would be determined as a defect or not defect without yourself being an inspector or an attorney. Or you might want to have the buyer and seller go under contract with a due diligence period. So, hope this contract tip helped you out. Dana Sparks, broker of Maximum One Greater Atlanta Realtors, satisfying your needs with service, innovation, and education.